может. То есть вот я могу сейчас вам демонстрацию показать прям. Смотрите, то есть экран. Смотрите. Алло, слышно?
Да, Паш, я тоже у себя проверил. А вот вижу Ульпию. Ульпия, hello.
Hi, how are you? I'm Menace.
Nice to see you. Yeah, sorry, I can't use my camera now, but I'm really happy that you were able to connect. So I suggest to start our meeting. I would like to say some beginning words. First of all, good morning, good afternoon, good evening, dear friends, dear colleagues. My name is Irina Chernych. I'm the Associate Professor of the Department of International Law at RUDN University, member of the International Institute of Space Law, and participant of the GEXLA. I would like to kindly remind you that today we have the last day of the RUDN University Space Week dedicated to the World Space Week, and our today's session will be dedicated to different aspects of living on the celestial bodies. We use online format and the Yandex Telemost platform. Before we start, let me remind that all participants are blocked from using mic and camera except our distinguished speakers and moderator. Listeners can see our broadcast and everyone can ask questions in the chat. You can mention name of the speaker to whom you address a question and ask whatever you want within the topic of the speaker. The topic of the World Space Week is life in space, and I would like to start, and with a great pleasure I would like to introduce our today's moderator, Ms. Elena Morozova. Elena Morozova is a very good friend of our university and our department and the center. Elena is Executive Director of the Intersputnik International Organization of Space Communications, and the course developer and the lecturer of the course International Space Law and Telecommunications Law within the master program International Public Law of the St. Petersburg University. Elena, as I said before, will moderate today. Thank you very much for the opportunity for joining in spite of all circumstances, and I hope that our last day of the RUDN University Space Week will be fruitful and very interesting. So, Elena, please, the floor is yours.
Thank you. Thank you very much, Irina, for your kind introduction. Indeed, we are very good friends, long-term friends with RUDN University. So thank you again for organizing such a timely event. And I would like to say good day to all our listeners, participants, all of you, and happy World Space Week to you all. I would like also to apologize sincerely for my voice. I lost it somewhere in Sydney, Australia last week, where the International Astronautical Congress took place. And the welcome was very warm, but conditions were very cold. So some of you also spent last week in Sydney, and I hope you feel much better than myself. But I'll try to speak not many words today. We will discuss aspects of living on celestial bodies. There are indeed a number of these aspects, including legal, political, strategical, also ethical and societal. And living on celestial bodies is no longer just a dream. The development of space technology brings us very close to this become a reality. So let's spend a couple hours together in discussing this interesting topic. We have a constellation of bright speakers today. It's a small constellation, not large, so we are sustainable in our today's session. Each speaker is allocated 20 minutes. We will continue with questions and answers. Just to reiterate that you can type your questions in the chat. And we will ask the speaker to help speakers navigate in time when you will be close to the finishing your presentation in terms of time, I will use the button to raise my hand. Please just pay attention to this hand. It is to help you to understand that the time is elapsing, and you are welcome to conclude and wrap up. We have a bit reshifted our program today to allocate all the requirements of our guests. So firstly, I would like to invite for a presentation Dr. Ulpia Elena Botezato of Romania. Dr. Botezato, thank you very much for joining. I was really mentioning yourself when I was speaking about Sydney, so I hope you are returned home safely and healthy. And it is a privilege to have you joined today our group of space enthusiasts. Dr. Botezato has first-hand experience in her talk. She will be presenting an action team on lunar activities consultations, which was established under the auspices of the United Nations Committee on the Peaceful Uses of Outer Space. And Dr. Botezato has really first-hand experience in this, not only because Dr. Botezato is the implementation support officer at GEXLA, at Moon Village Association, but also because Dr. Botezato is the chair of the Scientific and Technical Subcommittee and co-chair of this ATLAC group. So don't lose your chance to ask a question if you're interested in something specific and would like to see more details. Dr. Botezato, thanks again for joining. The floor is yours.
Good afternoon, everyone. I hope you hear me well. I didn't get home yet. I'm in London. I have been participating here to an event, and I'm in the lobby of the hotel where they incidentally decided to vacuum clean the hotel. So I'm really sorry for the noise. I couldn't find any other place better than this. Thank you very much for the invitation. It's an honor and a privilege to be here with you. I will do my best today to tell you a little bit about the Action Team on Lunar Activities consultation, which I believe is of interest to everyone here. Indeed, my name is Ulpia Botezato. I am the current chair of the Scientific and Technical Subcommittee of the UN Committee on the Peaceful Uses of Outer Space until February. Then I will pass over to my colleague from Thailand. I'm also the co-chair of this ATLAC together with Pakistan. My co-chair is Mr. Hassan Abbas. And I'm also support implementation officer for GEXA, for Moon Village Association. I also work for the Romanian Space Agency. So today I will try and put a little bit of context on this lunar activities consultation. How did we get to be here in this moment, and to understand why and how it was created. And of course, you can ask me anything at any moment. Unfortunately, I will have to leave this video conference like in 30 minutes to go to airport. But of course, everyone, Irina especially, has my contact email, and we can stay in contact afterwards. No problem with that. In response to the growing commercial and governmental interest in lunar operations, the United Nations Committee on the Peaceful Uses of Outer Space recognized in 2024 that existing frameworks were insufficient for managing potential interference as well as resource-related conflicts on the Moon. At the February 2025 meeting of the STSC, COPOS agreed to create ATLAC, following the proposal put forward by Romania. And the purpose was not to legislate resources or activities on the Moon, but really, because that task remains within the remit of the working group on legal aspects of space resource activities, but really to develop, to see whether it's a good thing to develop a mechanism, a consultative mechanism that could coordinate information sharing and prevent harmful interference with regards to activities on the Moon. Just to tell you a little bit about the mandate, ATLAC is tasked really specifically to have focused expert level exchanges to develop recommendations that enhance consultation related to lunar activities. This includes assessing whether to recommend an international consultation mechanism. So at this very moment right now, we have been establishing the ATLAC, we have been establishing the mandate, terms of reference, methods of work. We also have a list of priority topics, and we have almost monthly intersessional meetings with the members of ATLAC that are delegated by their respective member states. And we are in this very moment we are trying to create this very intimate atmosphere of trust where all member states to share as much as they want and whatever they want or whatever they consider necessary to share of their lunar activities, of course with an emphasis on challenges, so that we collectively discuss these challenges, but because most probably these challenges are addressing all the other member states, right? And so the team will prepare a final report for COPUA's 70th session in 2027. Of course, we also have, in case we cannot make it, but I hope we will. We also have some possibility of extending it to 2028. But we will have in 2026 interim proposals for these draft recommendations on the consultation mechanisms. And of course, we are trying to identify priority topics for this future proposed mechanisms. And we aim not to prejudice consultations under Article 9, or we aim not to duplicate any other work that is being undertaken under any other working group of the UN, whether in the scientific and technical subcommittee or a legal subcommittee, or really during the plenary, the political part. Just to tell you a little bit about the participation. So participation in ATLAC is open to all COPUA's member states, and I have to highlight that it's member states. Each state may appoint up to 4 representatives with diverse backgrounds, and I will give the example of Romania. We have been thinking that because currently we have only member states in COPUA's in ATLAC, we also would like to have the perspective of industry, because the industry is important. So we have incorporated in our note verbal, in our list of representatives, representatives from the industry, from the academia, also 1 diplomat, and I think that was it. In order to facilitate, so somebody from space agency, people from industry, and people from academia, and diplomats as well, in order to be able to really have this wide angle on what it means lunar activities, to take all the perspectives into account. And I think this is a good option for the moment. We haven't agreed yet, and I don't know if that will be the case in the future. We haven't agreed yet to what extent we will incorporate other entities, such as permanent observers, into ATLAC. And that is because we recognize that there is a level of sensitivity with regards to this lunar activities. And as long as all member states which are having representatives in ATLAC are not really pushing for opening up for the permanent observers, we are not. I mean, we as a chair, we are not pushing for that either. However, the idea for the future is that we will identify these challenges, that we aim to somehow cluster for technical challenges, legal challenges, and perhaps geopolitical challenges. We will discuss these clusters of challenges in the meetings which will happen during the subcommittees. And I really hope that when we will be able to identify these challenges, we will invite really experts on those points that we have identified, in order for the member states to be ready and able and capable to take informed decisions, whether it's important to have it for the future consultation mechanism or not. So this will, at least I'm sharing with you what are our ideas currently, and we will see how this will work in the future. So I mentioned the participation. This was the part related to the participation. Also, one more note on that: we are an action team and not a working group, and that's basically the difference between having only the member states, as in working groups are only having the member states involved, and action teams can also require the opinion, the expert opinion of other entities. And I'm not naming any other entity. It may be individual, maybe NGOs, maybe universities, maybe whatever. Like it doesn't really matter as long as their perspective is really important for the discussions we have. Nevertheless, at the end of the day, the end of our ATLAC process, we will have only member states voting, obviously taking decisions in that regard. Methods of work, and then I think I finish, and maybe we can have a couple of questions. Methods of work. So we operate under consensus. I mean, COPWAS operates with consensus, and we report our progress at the committee, subcommittee sessions. So it's a very good way of having feedback all the time. Meetings are held during COPWA sessions, the ones which are connected, as I said, with scientific and technical perspectives, with legal ones and with political ones. We get endorsement from the committee, but at the same time, we have intersessional meetings. So, for instance, we had an intersessional meeting in September where we asked member states whether they agree to have ATLAC report to this event that UNOSA is organizing in November. And also we had Russian Federation presenting a little bit of their lunar activities, which was a very, very interesting presentation. And we are working now in the background to really take out from that presentation the challenges that the Russian Federation identified, so that we would put it into a context and widen that scope of the presentation to address as many member states as possible, because this is what interests us, to really identify those challenges which are addressable to everyone, right? We will have the next intersessional next Wednesday. It's gonna be a very, very interesting intersessional, because it's gonna be the first intersessional meeting with the doors closed. So only the ATLAC participants, only the ATLAC representatives. And so we really, I mean, this is really my aim, to create this sense of trust among one another, among experts, because the experts are being represented there from each member state, to really be able to push this sense of trust, so that everyone would feel comfortable enough and share the information, or share the whatever they want to share in a place that is really would make sense in the future to really build something upon. So this is my hope. And I really want to thank, with this occasion, Russian Federation, because they were the icebreakers last month, and I think it was incredible that we had that presentation. Unfortunately, we didn't have much time because we had some other topics, and the discussion became very long. But I intend to actually restart the discussions this coming Wednesday. One more thing I should say, UNOSA, United Nations Office for the Outer Space Affairs, is offering the secretariat for this action team. So they offer their support in that way. Meetings are in a hybrid format. Of course, we encourage people to come in person, because it's always nice to interact in person. But of course, like, it's up to each individual how they wanna join. And I think with that in mind, that's about it. What I wanted to share about ATLAC. Really, this is an emergence from a recognition for the need of coordinated lunar activities. And I hope that everyone finds this useful enough to open up and really build something in a sustainable and durable manner. And I am here to answer any questions, if any. Thank you very much.
Thank you very much for this information about ADLAC. It's so widely spoken and follows great interests. Of course, we all wish you every success in this endeavor. We have a couple of questions. The quick and very brief from myself, I would also like to use this opportunity. You mentioned for a couple of times that trust is very much important. It's absolutely true and understandable. You also mentioned that this closed room format will perhaps contribute to building trust. Do you perhaps have some other ideas or some other life hacks how you form this feeling of trust, how you invite member states to break ice, for example, like you also mentioned? Does it really help that in the delegations are including so many different representatives? I mean, in terms of their background, lawyers, perhaps diplomats, and also like engineers. Just a couple more words. Thank you.
Thank you for the question. It's really important. I will tell you something very honest here because I think I am among friends. In our mandate, it's not written really that we need to form trust, right? Trust is something that me and Hassan, as co-chairs of this initiative, we thought it might help. And of course, the United Nations has a lot of instruments. Of course, there is this resolution on confidence and what is that, trust and confidence building measures, right? But I will not refer to those ones because this is not what I mean. When we said that we want to have this intimate space, we had this inspiration, another working group at COPUOS, and that is Working Group on Nuclear Power Sources in the Outer Space, where people are knowing each other and they know their level of expertise. And I'm sure we can create something alike. And they are sharing information because they know each other, because they trust one another, because there is no, there are no lies. There is no sort of, nobody wants to do anything else but really to work in a productive manner. And this is what we are trying to do in ATLAC as well. We recognize that there is a need and we want somehow to bring everyone at the same table and to speak about it, And I understand, there are many geopolitical sensitivities here, but we don't look at those ones because it's not productive. We would like to really focus on whatever we have to do, that is discuss about lunar activities, and leave all the other geopolitical implications aside. And of course, having the same sort of group that gets, just to tell you a little bit about this grouping thing, when we decided that we need to have a closed group, we took into account particularly the fact that members of delegations were changing every meeting. And we don't want that. We were starting for 1 year every meeting by recalling the mandate, by recalling what we need to do here. And we got tired of this. That's not the point. It wasn't productive. So we said, okay, let's just, each individual member state just decide who it has to be inside, what are the most representative people in their member states. And so these people will actually be able to follow and build upon whatever we're discussing every session. So this was the idea of having this closed group, not really to close ourselves in front of the world, but really to have this continuity of conversation so that we would reach a deep enough level of conversations, that was, and of course we can also be friends, that is the added value of it. I hope that answered the question.
Yes, indeed, it was very exhaustive question. And we have time for one perhaps more question. And I would like to read it from one of our listeners. By the way, there are many words of thanks to you in the chat. So the question is how the ATLAC process has contributed so far to shaping or strengthening the international legal framework and governance structures for lunar activities. And looking ahead, how do you see ATLAC potentially influencing the legal architecture for lunar governance? Do you envision it becoming a normative platform or more of a confidence building and transparency mechanism?
Thank you for the question. A very, very important question as well. Currently, I think we have contributed to creating this understanding, general understanding that we need to talk about lunar activities, lunar cislunar. So I think because we have, I mean, no, because we had the need, then we had the initiative, then this initiative clustered people, organizations, member states, and then we kind of created this platform, so to say, this action team. So we haven't influenced much. It's just an effect of the fact that we need to talk about it. For the future, of course, by 2027, we would like to make the recommendation whether we need or not. This is, I don't want to prejudge that, right? I myself consider that we need, but we have to reach that conclusion, right? So by asking member states to share whatever challenges they faced, or they believe that they will face in the future, we really want to cluster these challenges and see how can we be of support, you know. So for the future, I envision that we will be able, hopefully, I don't know, one possible outcome is that we will be able to recommend a consultation mechanism, the creation of a consultative mechanism at the international level. That means not amending, but adding to the current international framework, the lunar activities part. So we will see. In 2027, maybe we will have the opportunity to speak again, and then I probably, hopefully, be able to tell you more about that.
We definitely look forward to 2027, and once again wishing you all the success. And with that, let me thank you again for your time spent with us, and we wish you safe travels back home finally. Thank you very much for being with us.
Thank you.
And all speakers joining in applause. Thank you. Dear participants to our World Space Week session today, we will continue with our agenda, and I would like to invite our next speaker, Dr. Günis Ünüvar of Turkey, who will share current status of affairs at the working group on legal aspects of space resources activities, also a very much important endeavor taking in the United Nations Committee on Outer Space Affairs. Dr. Ünüvar is legal advisor at Moon Village Association. Dr. Ünüvar, the floor is yours. Thank you for being with us today.
Thank you very much, and also for the invitation. I will try to share my screen. Just a second. Okay. I hope you can see it.
Yes, we can.
Okay. Okay, so once again, thank you very much for this invitation. I propose actually to talk a little bit about a topical issue, given also the scope of the panel. I am the legal advisor of the Moon Village Association and also a board member. And for those who are not familiar, MEA is a non-governmental organization focusing on establishing and fostering multi-stakeholder, inter-stakeholder dialogue. This may be states, other NGOs, as well as the private sector, the public sector. So our focus is mainly on lunar governance. I also see, I think it's an interesting question that came up. Maybe I can also answer that from the outset, that MEA is a non-governmental organization. How can it decide anything in the field of space legal framework? We are a permanent observer. Of course, we don't have a vote, or we are not in a position to decide anything. It's for the states to decide what the international legal framework is going to be. But NGOs like MEA and many others sit in that room as permanent observers and voice their concerns, voice topical issues, bring this to the attention of states, which is then of course picked up by states in many cases. So we are part of the dialogue, but of course that doesn't mean that we get to decide anything on our own, and that's really hardly the point. Maybe that's an important clarification on the outset before I talk about this very, very important subject. And for those who are not familiar with the current progress of the process of the legal subcommittee at the moment, the working group on the legal aspects of space resource activities within the legal subcommittee is discussing the draft principles on space resource activities. This is a series of very, in my opinion, consequential rules on how the international multilateral space resource governance will proceed in the future. And I was in Vienna earlier this year, again in my capacity as an observer from the MBA delegation, and I had the opportunity to extract some impressions as to where we stand and how things might develop in the future. So the working group on legal aspects of space resource activities released an initial draft principles text on space resource activities in March 2025. Of course, it was available to the states, members of the working group, much earlier than that. And then a revised draft, an updated draft, was made available in June, and it was published, I think, in July on the COPOS website, or earlier the first half of the summer. The discussions, both formal and informal, have mostly converged on the preamble of these draft principles, the titles specifically of the 9 initially drafted principles, as well as a few additions, additions that were also discussed. But again, so far, the delegations haven't really discussed the provisions themselves. It's mostly about the framework of each principle. And again, the discussion centers around key debates about shaping lunar and space resource governance and how this international framework will govern them. There are 9 draft principles, as I mentioned, and a few bracketed additions, and the preamble very clearly, unequivocally notes that the Outer Space Treaty is the cornerstone of space law, and it will also likewise guide the way that these principles will function in the future. It stresses, again, perhaps unsurprisingly, peaceful purposes, sustainability, equitable benefits between different stakeholders, and it makes clear that these principles are non-binding recommendations. So this is not a, so to speak, 6th space treaty. They essentially complement what's already ingrained in international space law. They do not really replace these rules that are in place. Specifically, the June draft organizes its framework again around these 9 principles. It also introduces the brackets that I mentioned on definitions, the operative definitions, monitoring of compliance with these rules, review, control, and cooperation. Now, of course, even though the discussion has been on the titles essentially, the important point of consensus again that we have to talk about where states agree and where do they disagree. There is broad consensus on a few issues. Number 1 is compliance with international law. This is really something that's beyond debate at this point, that international law, public international law, or space law, international space law has to be complied with. Second, activities must be for peaceful purposes. As I will touch upon this a bit, there was a brief discussion about whether the language should be exclusively for peaceful purposes or just peaceful purposes should be retained, which is, I think, an interesting, let's say, divergence. Third, there are long-standing obligations on safety and rescue that everyone, at least in principle, appears to agree. And fourth, due regard and consultation to avoid harmful interference, again, in principle, are seen as basic requirements, but how that exactly plays out can differ from one state to another. There are also, of course, important divides when we're talking about an issue as controversial as space resource activities. On ownership of resources, there are clear divides, I would say, on the prioritization of scientific activities, for example, on environmental obligations and what these obligations entail, on mechanisms for international cooperation and oversight, and the exact implication of what the Artemis countries call the safety zones and risk of de facto appropriation. So I will try to sort of skim through these principles because there aren't that many. And the state positions that I reflect here are not necessarily things that were raised during the informal or formal meetings, but also there are publicly available written statements that you can all find on the POPO's website. So it's a bit of a mix of these impressions. Principle one generally, again, enshrines compliance with international law. There's broad support for the OSD's centrality to this effort. The emphasis on the written statements, in particular by Indonesia, Russia, China, there was a big emphasis on the OSD. And perhaps somewhat surprisingly, Russia's emphasis on the Moon Agreement was noteworthy, in my opinion. US and Canada, countries that are, we can sort of maybe somewhat cautiously put together as the Artemis countries, tend to reject the moratorium language, which sort of, I guess, aligns with their view that there should be a certain commercial angle to these space resources, because there's obviously an encouragement of the private sector. So that's more of a chapeau sort of position that US and Canada and many other Artemis countries tend to uphold. And an interesting point that was raised is that Turkey made a reference to international law in a way that the in compliance with international law language should be somewhat qualified so as to exclude certain international law rules and norms that are not perceived to be universal. Though it's again not entirely clear to me what the exact problem there was. I have some theories, but let's just leave it at that. In principle 2, we have the freedom access and non-appropriation. This reaffirms the OSD's non-appropriation clause. This is again, in principle, a non-debatable rule that states or private entities or non-state actors cannot really claim ownership of a celestial object or claim a certain territory for their own by means of sovereignty or by any other means. There was, again, in line of also with the signature on the Moon Agreement, there was some Moon Agreement arguments that were put forward in this context and some common heritage language that was adopted. Some examples are Iran, Indonesia, and France. And on the other hand, in the written submissions of US, Luxembourg, and UAE, in line with their national laws, we see an emphasis on having a certainty in terms of ownership, the possibility of ownership of extracted space resources. And one thing that stood out in Russia's written statement, for example, is that sort of opening the gates to this might lead to what they refer to as creeping sovereignty. That's not a direct claim, not an explicit claim, but sovereignty by its effects. I think we can sort of summarize it that way. And there was also some pushback because the draft text, according to some, echoed the Artemis Accords language. On principle 3, again, coming back to the peaceful purposes question, this generally commanded, I would say, broad agreement. Everyone agrees and insists that space activities should be done on peaceful purposes, but the debate was, at least verbally at this point, was about whether to use the word exclusively in the text. I think this is also in the updated bracketed language that's in the July version. China, Russia, and Iran, for example, among others, my impression was that the preference was towards strict wording, that it should be reserved only to peaceful purposes without any sort of room for divergence. the bloc that's mostly the Artemis Accords countries sort of expressed their reservation that this could exclude military affiliated entities that provide logistical support that are conducting peaceful activities. Just because they happen to be military personnel doesn't necessarily mean that it's an unpeaceful activity. So, and this is likewise not prohibited under the OST. It's an explicit sort of carve out, if you will. So I think that's one of the main somewhat semantic contentions, which does have important normative implications as well. On principle 4, which restates the duty to prioritize human life and to render assistance in emergencies, fairly unanimous support. The real controversy, I would say, when it comes to safety is relating to safety zones, which is a term that is really captured very popularly, very famously under the Artemis Accords. The resource sites sort of being declared as safety zones is a concept that's being pursued under the Artemis Accords. The US and Artemis countries likewise generally are in favor of this particular language, though there was some pushback in principle that there could be some sort of de facto territorial claim, especially if these safety zones, which are ostensibly temporary zones, might extend, sort of resulting in some sort of de facto territorial claim. Some observers also chimed in at this point, noting that these zones definitely should be temporary. There's no question they're limited in scope, and assuming that they're going to be tied to the Artemis framework, it should be tied to this due regard framework under Article 9 of the Outer Space Treaty. This issue is bracketed at this point, so we will see how that sort of evolves, I suppose, in the next cycle of proposed events. Principle 5 is quite a developed principle. I think this is also something novel in this form and shape. Germany, Indonesia, and Iran, in their written statements at least, have emphasized the importance of environmental impact assessments, adopting a precautionary approach, which, as you know, comes from international environmental law. And one interesting development recently was the ICJ's climate opinion, which I believe adds momentum to this and sort of encourages us to think about the impact of space activities on Earth. Some observers were quite adamant about sort of having a system of mandatory reporting and having a protected heritage framework, also something that's found on the Artemis Accords. Some countries expressed their preferences to more flexible approaches, like, again, US, Luxembourg, and UAE. This perhaps was the most interesting to observe, also both on paper and on during the discussions. So there is a block, if we might call it that, even though the views expressed diverge significantly. The importance of science is something that everyone, to certain degrees, seem to accept. Likewise, if you look at the written statements of France, China, Germany, and Russia, there is a certain emphasis on science being an important aspect of outer space activities. Though not all of these states have emphasized that there should be an absolute priority of scientific activities vis-a-vis, for example, commercial activities. Certain countries like US, Canada, Luxembourg, Japan, UAE, which have space resource laws, except for Canada, the 4 of them, they did sort of push back against the hierarchy of different activity types. But notably, Russia, I would say, was quite adamant about science by virtue of being referred to in the Outer Space Treaty, having a certain primacy over different kinds of space activities, which is a noteworthy position that I'm sure will invoke very lively debates going forward. One thing that really was interesting was to see Russia's referral to the Moon Agreement repeatedly. Especially the emphasis on scientific research, the fact that space resources are not necessarily subject to ownership, etc. So we see that there's sort of an embrace of some states, including Russia, on the Moon Agreement language. Again, this is a very divisive subject. I think this is where we will see a lot of discussions, a lot of debate, and a possible compromise. And I've written about this recently as well. And a possible compromise, long story short, could be a non-undue interference or a situational prioritization or a sequential treatment of how these activities could proceed. Taking into account also that scientific activities can go hand to hand with non-scientific activities, among them commercial activities, assuming that they are ultimately allowed. Transparency and consultation is also very important issues under Principle 7 and 8. France and Germany were two countries that sort of argued for detailed reporting and consultations. And then we had observers like, for example, Secure World Foundation proposed standardized transparency measures, and US in particular supported coordination, again, particularly within the Artemis framework, in especially safety zones. Again, the likely compromise I would see here is transparency requirements combined with flexible, nationally managed or operationalized coordination. But again, we'll see how that goes forward. And we would have to know more about the specific operational details of how safety zones are going to be managed in the first place. Principle 9 revisits Article 6 of the Outer Space Treaty, which defines international responsibility to states as they are responsible for all national activities, public or non-state, private. The innovation here really is the possible addition of environmental impact assessments, I would say, and broader ethical considerations into authorization regimes that states nationally implement. And countries like France, Italy, Indonesia, Iran support these primarily national safeguards. Russia and China seem to be on the strict state primacy camp. Again, these views are expressed differently, but if we sort of clump them up somewhat superficially, we could say that. And Luxembourg and other, I guess we could call investor-friendly or private aligned states prefer lighter, predictable regulation to encourage private operators to be able to operate in these celestial objects. And this principle could, at least in theory, become a vehicle for integrating a series of environmental and ethical safeguards into national licensing systems. But again, resistance is somewhat there. Some bracketed principles, and I will go somewhat quickly here. These were proposed in the course of the meetings, and three new ideas are emerging. One of them is international cooperation, capacity building, benefit sharing. We see some developing countries call for technology transfer and benefit sharing. Control, Russia and China floated the idea basically that an international body could be put in place. There was opposition to this, perhaps unsurprisingly. A review and monitoring of these principles sort of reflect a very progressive adaptive governance model, so that's actually, I would say, promising. But states disagree on the scope and frequency and enforcement of these review processes. Some states, we can say that they're more focused on equity. They want binding regular reviews, and then we have the more private investment-oriented countries have more voluntary preferences. So, interestingly, there was an explanatory note that was proposed as an alternative to the current preamble. This text is also online available. This likely came from an Artemis country or Artemis aligned country, because the language very much refers directly, explicitly to the Artemis Accords, though I don't really know who that would be. Likewise, this is, I would say, attractive to the Artemis signatories, but it certainly creates certain controversies for non-Artemis countries. Russia, China, Iran, for example, may find this somewhat unilaterally framed and not necessarily reflecting a multilateral consensus. And there was a certain voluntary and non-binding tone to it, which again reinforces my impression that this might come from an Artemis country. So unless the language is balanced in terms of also sustainability, intergenerational equity, this alternative preamble might risk being divisive. So conclusion, where do we stand? We have a solid base for consensus. As I said, OSD remains to be, even in the most divisive of times, remains to be a common ground. And a lot of the principles enshrined under the OSD remain universally upheld. Well, hard questions nonetheless remain, again, how to balance ownership rights, assuming, again, there will be a multilaterally accepted ownership framework with non-appropriation principle, how to protect science without freezing out commercial development, how to embed environmental safeguards without stifling innovation, this is at least the concern of some, and how to design review mechanisms that are both adaptive and to some extent, of course, predictable. So the compromises will have to be very, very carefully crafted. I have to say, scientific activities will, at some form or shape, take a specific mention, and they will have to be, I guess, positioned vis-a-vis non-scientific activities in some form or shape. But again, this is yet to be seen when the states, the members of the working group, start discussing the specific provisions. But I am very much looking forward to where these debates will take us. Thank you very much. With this, I finish my presentation.
Thank you very much for this helpful overview. It is actually for the first time I see such a deep analysis, what is very helpful from different states and group of states, specifying different views and the variety of views. Thank you indeed. A quick comment and a couple of questions which we already have. You referred to Turkey, who make a reference to international law or suggest to somehow specify which branch or somehow else specify what is meant. And you also mentioned that you have some theory in that. I can only wish you good luck in understanding this position and would be happy if you could sometime later share your thoughts, because actually I have noted that Turkey is very resistant to any mentioning of the law of the sea at the cooperates with the terms of space resources or else otherwise. So something interesting might be as a root of this reference or objection or something else. As for the questions, two of them actually. Firstly, you mentioned for a couple of times that states do refer to the Moon Agreement, even those states who are not parties to the Moon Agreement. Of course, Moon Agreement is mandatory for states parties, but anyway, it is a source of international law. It's a treaty. But do you think that such references may mean that perhaps if the group on space resources will be successful, that principles will be more or less agreed upon, and maybe we will be closer to establishing an international framework for these activities? Do you think it will be a kind of a second wind for the Moon Agreement? Will be more states be interested in joining it? And the second question, so you can answer both of them simultaneously. Perhaps you will see that we have continued in the chat some discussions on non-governmental organizations' role at the UN system-related work, but perhaps a quick comment from yourself as well. As a permanent observer, you know the methods of work and how it is settled, that observers can still present conference room papers and also speak on the agenda items. Do you really think that it is quite a balanced approach to non-state actors to also have a kind of a say at this primarily interstate forum. Thank you.
Thank you. Maybe I can start with the second one. Well, non-state participation is not exclusive to COPOS. I think it's very much embedded in the UN system. You can find it in other frameworks like UNCITRAL, for example. And really, the point isn't to ultimately push a hidden agenda for NGOs. I mean, not to speak for all NGOs in the world, but I think the point is that there is a certain vetting system that the UN has put in place, and in certain committees, if you are an NGO and if you want to take part in a particular committee or working group, bringing a certain non-state perspective to a truly global issue can be very beneficial, I think, speaking very broadly. Of course, states are the ones who are engaging with the operative discussions. They're the ones who decide on texts. But I also feel like the UN system and members of the UN, members of specific committees and commissions within the UN have generally been very open to NGO participation, or rather observer participation, because not every observer is an NGO as in, they're pursuing a certain agenda. We have academic institutions, right? We have universities, research institutions. So I think to create a truly global discussion around these issues, non-state participation in these debates is fundamental. That's how I see it, at least. On the context of UNCITRAL, for example, the Commission on the International Trade Law, I also used to go to Vienna on behalf of my former university, and we were there to share our empirical research with delegations on, for example, investment arbitration statistics, damages calculations, etc. This information may not be readily available to every state, so there's certainly a scientific contribution as well, more so in the context of space, because we have International Telecommunications Union, like with NGO observers within the UN framework as well. So I think I consider this to be an enriching addition and not necessarily somewhat of a cynical way, a bunch of NGOs trying to push their agendas into the framework. I think that would be misrepresenting the situation. Now, the first question, and thank you for raising this, because at least my observation was that Russia was very straightforward about the position of the scientific activities vis-a-vis other activities, and there was a lot of reliance on the Moon Agreement, which did stand out to me. I think Moon Agreement, beyond the technicalities about ratification and signing, I think it contains a number of very valuable principles. And I agree in that sense that even though many states are not signatories to it, that doesn't change the fact that it's a treaty that is currently enforced. It's part of international law, though its application might be somewhat qualified compared to more widely accepted treaties like OST. I don't necessarily believe that a treaty, it doesn't even have to be a treaty. I think willing states relating to a particular set of principles can also rally behind a non-binding instrument as well. We have many soft law instruments today, guidelines on long-term sustainability, space debris guidelines, etc., that garnered a lot of support. So I don't necessarily see that as a sort of sine qua non situation. Would this prompt states to sign the Moon Agreement? I would be happy to see some states to sign the Moon Agreement and to sort of own up to it. Do I think it's going to happen? Realistically, maybe a certain bloc would, to sort of make a point and to rally behind a set of principles, maybe. But do I think this is going to happen universally? I highly doubt that. Again, this is not a reason not to rally behind a set of principles and sort of push forward a position in the form of a bloc. That is being done, for example, in the context of the Artemis Accords, right? This is a collection of interpretative provisions, basically, getting behind the OST from the lens of the Artemis Accords and this is sort of pushing forward a normative framework into the multilateral agenda. I don't see why this cannot be done from the lens of the Moon Agreement. There's also a lot of, for example, when you look at the work of International Institute for Space Law, another observer, by the way, has a working group on Moon agreements, right? Where they are basically working on how do we revive the Moon agreement and make it quote unquote relevant again. So I would definitely like to see more Moon agreement discussions in these debates, but I would also see some sincere commitment and states to actually sign it if they're really, really passionate about the Moon agreement.
Thank you very much for your time and for your presentation and taking care of our questions. There is something ongoing on the chat, so if you have some time and appetite, we invite you to continue chatting with our participants. Thanks again for being with us. A great round of applause from our side to yourself. And we will continue with our program for today. Thanks again. We will now move on our agenda today to discuss some other related matters and specifically what does it mean to live on the moon and which can be those legal reflections on human activities on celestial bodies. And I would like to invite our next speaker, Dr. Yu Jianqing of China, who is postdoctoral researcher at the Center of Comparative Law at Shenzhen MSU BIT University of China. Thank you very much for being with us. It is not for the first time you're joining RUDN Space World Week panels. The floor is yours. And we see your slides.
Okay. Can you hear me correctly?
Yes, we can hear you, but please make sure that when you will be switching between the slides, I will let you know whether we can see the next slide. Now we have like a presentation in PowerPoint and the very first slide.
Okay, so I will continue. Good afternoon to Moscow, to colleagues from RUDN, from other institutions, and places around the world. For me, it should be a good evening here in Shenzhen, China. Well, my name is Yu Jiaying from SMBU, Shenzhen MSU BIT University. As the moderator introduced, I'm currently working as a postdoctoral researcher on space law at the university's Center of Law. So I'm very glad and honored to join the RUDN Space Week and talk about space law for the second time. Thank you very much for including me in this session. I have been working on legal aspects of lunar exploration, while particularly interested in lunar station activities and related legal issues since my doctoral study started back in 2020. And I have continued this line of research into my postdoc research. So my own research is rather theoretical one. So I truly appreciate it and learned a lot from the previous speakers' presentation who have participated in the UN Global agenda. And that gave me a very great chance to observe the practical, lawmaking or the promotion of lawmaking aspects that an early researcher can hardly cover. So comparing to your practical experiences, and maybe I will try to share my reflections from a rather theoretical perspective as another part, perhaps supplementation for today's session. So I suppose it will not be as informative as the previous one presentations, but it will be a genuine sharing of my own reflect about this topic. And from today's sharing, I might get the idea of whether the way I do my research is feasible and whether it is actually addressing certain research gaps. So today, I would like to share with you some of my recent thoughts related to the legal aspects of living on the moon in response to the session's title of living on celestial bodies and legal aspects. So in my presentation, I take lunar activities as an example of living on celestial bodies. So to understand this topic, I identify two major keywords here, one of which is the moon, or the celestial body, and the second keyword would be living, so referring to human presence on the moon. And my presentation is based on these two keywords, and I will try to mention some of the potential legal aspects related, reading along with the outer space treaty articles. And there might be some overlap with some legal aspects mentioned by previous speakers. So I will try to focus on those that provides me more reflections, and that includes whether scientific purposes of utilizing lunar resources can be considered as a normative tool in the lawmaking process. And when there are people living on the moon, the second part, what can space law do about safeguarding life and health, which I presume it would be very much related with the keyword living. And finally, I will conclude by bringing up the necessity of international inter-program legal mechanism regarding living on celestial bodies. So to begin with, let's take into look some technical features of celestial activities that I have summarized here from a space lawyer's perspective. Activities on a celestial body involve, first of all, international cooperation, and secondly, use of lunar service areas or celestial service areas, and inevitable use of natural resource on that celestial body. And this characteristic leads us to the legal aspects of many aspects. For example, the need for international mechanisms, tensions between non-appropriation, freedom of use, lack of resource management mechanism, and safety zones, functional areas, and related controversies regarding the due regards principle, etc., and the military concerns in lunar activities, which are inherent to most areas of space activity and likely to affect lunar activities as well. Well,
Dr. Yu, my apologies for intervening. Do you switching your slides? We still see the very first slide. If you switch,
yes. I guess I should change the screen sharing mode. Just give me 1 second.
Or perhaps you have to somehow switch the slides in another mode, or perhaps if we have slides, we can do it for you.
Maybe I can just use this window.
Yes, this works. This works. Now we can see part one.
Okay, I understand. I was going with on this one. Yeah, so I should just go with this window, and then let's continue. And we were just talking about those different aspects of activities on another celestial body. Well, among these aspects, I would like to share my recent thoughts about potential function. Previous speaker have mentioned in the lunar resources principle framework, one of which is the scientific use principle. In forming a normative framework, so I look into the question about, can scientific purposes of lunar resource utilization guide the rulemaking process? This part is explaining or connecting with the first keywords of this topic, which is celestial body or lunar. So the first part, freedom of scientific investigation as the legal evidence. Well, in the international legal framework governing outer space, the principle of freedom of scientific investigation established in Article 1, Paragraph 3 of the Outer Space Treaty is served as one fundamental legal basis for promoting activities living on another planet. And this provision explicitly states that there shall be freedom of scientific investigation in outer space, etc., and states shall facilitate and encourage international cooperation regarding scientific investigation. So this principles affirms the right of all states to conduct scientific research in outer space, including on the moon, and reflects the Outer Space Treaty's intent to promote cooperation and non-exclusivity in space science. So viewed in conjunction with the common interest and freedom of exploration and use principle stated in the Article 1. The freedom of scientific investigation provides normative support for lunar resources management from these dimensions. Well, first of all, from the perspective of rights, the provision affirms that the freedom of scientific investigation is an important right of states in outer space activity. It legitimizes the state's ability to independently carry out scientific exploration and supports activities such as deploying scientific missions, scientific facilities, lunar stations, lunar research stations, and engaging in cooperative research. And secondly, from the perspective of obligations, legal obligations provided by the treaty. And this provision requires states to facilitate and encourage international cooperation in scientific investigations. It is not only entails a positive duty, but also implies negative obligation not to take any action contrary to this purpose, which is not to hinder or obstruct the normal conduct of scientific activities of other states. And thirdly, scientific activities hold special significance within a broader context of outer space activities. Article 1 of the treaty establishes the principle of common interest, freedom of exploration and use, and freedom of scientific investigation. Although the treaty does not assign hierarchical weight among these principles, perhaps, but from both the structure and the overall purpose and idea of the treaty, scientific freedom may be interpreted as a key means or way of implementation of the other two principles. Moreover, the treaty emphasized the freedom of scientific investigation in a standalone paragraph, accompanied by requirement to facilitate and encourage international cooperation, which may indicate its normative priority in the conduct of outer space activity. So in the current and future lunar missions, scientific activities due to the cooperative and non-competitive nature perhaps enjoy a broader international acceptance than other purposes such as commercial uses previous speaker have mentioned about in the ongoing discussion under the UN Co-4's agenda. Although the Outer Space Treaty does not explicitly prescribe a rule of scientific priority, its underlying spirit and normative logic suggests that the principle of scientific freedom constitutes a crucial foundation for ensuring the peaceful conduct of outer space activities and promoting international cooperation. And scientific research is a practical foundation for long-term deep space exploration. In the current and envisioned future lunar activities, scientific research is not only the primary rationale for international cooperation, but it is also the technological foundation and source of legitimacy for future lunar habitation, resource utilization, and further deep space exploration. And promoting scientific research, scientific investigation as a way to mitigate tensions and build consensus among lunar resource competition. The potential exploration, exploitation, the value of lunar resources, especially resources like water ice, rare metals on the moon, has already grown significant international attention. However, in the absence of clear rules among divergencies, premature resource, early resource exploitation may intensify conflicts, and in contrast, science-oriented activities such as resource surveys and sample collection are more likely to gain international recognition due to their perhaps non-competitive, non-commercial, and open nature. And they lend themselves more easily to the establishment of multilateral coordination mechanisms. So therefore, promoting scientific investigation from a regulatory perspective is not only necessary for the technological development needs, but also one of the crucial, important means of easing tensions and delaying conflicts. Legal interpretation and normative interpretation of lunar resource utilization for scientific purposes. From an international law perspective, I presume distinguishing between resource utilization for scientific purposes and for other purposes, for example, commercial purposes, is not only for assessing, should I say, the legality of lunar activities, but it also shapes how the states define their negotiation positions and normative claims in future rulemaking process. And within the current framework of space law, scientific activities can be interpreted as one concrete implementation of the principle of common interest and freedom of exploration and use, like I previously mentioned. So limited use of lunar resource for scientific purposes, which is also the idea provided by the Moon Agreement, may therefore be viewed as a necessary component of such activities. And this interpreted approach might be theoretically acceptable for other states, but also provides legal justification to advocate reasonable resource use, technological cooperation, and the science-oriented initiative in future multilateral dialogues. And currently, whether in the Artemis or the ILRS plan, official documents have emphasized scientific objectives and multilateral collaboration. And also, like a previous speaker have mentioned, China, Russia, Germany, France, and some other states have already submitted documents to the working group of space resources, legal aspects, mentioning that we should promote scientific uses at this moment. And the second part of me reading the keywords of living under this topic is about human presence on the moon. So now let's turn to long-term human presence on the moon. It may be the next step in our efforts to ensure the sustainability of human exploration, living beyond the Earth. So I guess that would be the ultimate reason why we are discussing the very idea of living on a celestial body. And from a legal perspective, in early human presence on the moon, it can be related to the two legal aspects here, jurisdiction and the legal protection of human life and health on the moon. So regarding the jurisdiction issue, aspects of human habitation on the lunar surface, I personally presume that this aspect is well covered by the existing space law and practices, especially Article 8 of the Outer Space Treaty and Article 2 of the Registration Convention. They establishes that jurisdiction over space objects and personnel thereon is retained by the registry state. So in multinational missions, states can agree on jurisdictional arrangements on whether it is one single state retaining the jurisdiction over all parts of the lunar habitation, or different states retaining jurisdiction over different modules or components of the habitation on the moon. What I would like to share is my recent thoughts about legal protection of life and health on the moon. In the context of lunar living, while the protection of personnel on a lunar surface could be an issue that need to be considered in early stages of lunar habitation. So this issue involves the interpretation of Article 5 of the Outer Space Treaty and the Rescue Agreement. So firstly, Article 5 of the Outer Space Treaty provide a foundation which states that astronauts are envoys of mankind and must be assisted in distress. The specific obligations of states parties under this article includes the rescue and the return, and the obligation rendered to render assistance arises when astronauts encounter accidents, distress, or emergency landings. The final one includes circumstances in the territory of another state party or on high seas. So when the term emergency landing may appear to be encompassed by accidents or distress, its inclusion emphasizes the territorial scope, that even if such incidents occur outside state parties' own jurisdiction, in the territory of another state party or on high seas, assistance must be rendered. So in the lunar context, Article 5 implies that if a state party conducting activities on the moon becomes aware that There are astronauts having encountered distress or accidents. These states must undertake rescue and return obligations. Although there is no possibility of an emergency landing while in the territory of another state party or on the high sea on the moon. So it depends on interpretation, perhaps. Astronauts may encounter distress within a lunar habitation, which is under the jurisdiction of a certain state, of course, or on the lunar surface where it is not under the jurisdiction of a certain state. So wherever such incidents occur within the rescue state's own station or within another state's station or habitation or jurisdiction would be one legal factor to consider under these circumstances, maybe. And they all fall within the scope of obligations under Article 5. The state must render assistance and arrange for return in both cases. Well, furthermore, the article refers to astronauts as envoys of mankind in outer space, though it does not confer very specific privilege based on the treaty's value of peace, peace, equity, cooperation, and sentiments of humanity. And this phrase can be interpreted as the recognition of astronauts' pioneering role in human space exploration on the moon. So combined with the obligations of rescue, return, it also reflects an legal expectation that states will act in good faith and humanitarian spirit to assist astronauts in distress on the moon. And the rescue agreement and its applicability to lunar context. And regarding the rescue agreement, however, it was drafted with Earth-based emergencies in mind. For example, cases of emergency landings in foreign territories or high seas, places not under jurisdiction of any states, not situations on the moon. So it remains an open question whether the rescue agreement can apply directly to lunar emergencies. And notably, the rescue agreement distinguishes in its Article 2 and 3 between incidents occurring within rescuing state's jurisdiction and those occurring outside of it. So in these two scenarios, the obligation is different for the state. One would be mandatory and the other is not compulsory. So in the lunar context, if we interpret the rescue agreement as certainly applicable on lunar surface, so this distinction might be a good reference for future international cooperation or coordination on astronaut assistance on lunar surface, particularly in delineating the respective obligations of states within and without the jurisdiction over specific lunar habitation. So in any case, the humanitarian sentiments underlying the rescue agreement remains relevant. In future emergencies on the moon, we may need additional mechanisms for rescue and assistance, potentially through international coordinated frameworks, which is currently what the UN COPOS frameworks are working on, I assume. And that continues with the last part of my reflection today. So here are some of my current thoughts. Well, multinational cooperation is a very important part for human presence on celestial bodies. Coordination mechanisms are needed, not just for intra-program cooperation, for example, Artemis Accords, but for inter-program coordination, which is also are important across national blocks. Lunar resource management, for example, the international cooperation could reduce conflict over limited resources such as ideal landing sites for lunar habitats. And the scientists have identified specific lunar regions, for example, South Pole or Equator on the Moon, as suitable for lunar habitation. If multiple programs, for example, they aim for the same locations without coordination in advance, disputes may arise. And the other issue I have mentioned today, protection, safeguard of life and health of people on the Moon to enhance cooperation on common interest. Well, for example, if a person experiences an emergency on the Moon, the fastest or only assistance might come from a nearby station, habitation of wherever country jurisdictions. So the assistance and rescue can be more efficient when such inter-program coordination is ready. And therefore, the value of legal frameworks goes beyond promoting national interest. I guess they are essential for ensuring safety and sustainability of human activities on another celestial body. So my final remarks regarding what does it mean to live on the Moon? Well, to me, living on the Moon requires more than just technological readiness. It implies also the necessity of legal frameworks developed in advance as a part of our broader preparation for sustained human presence on the Moon or other celestial bodies. And these legal frameworks, binding or non-binding, are essential. And in particular, multilateral coordination across different living program on the Moon is important to address emerging legal and practical challenges. So survival on extraterrestrial bodies is no longer a distant dream, as becoming a tangible reality. The mission of public international law in this context is to safeguard and promote the shared values of peace, cooperation, long-term sustainability on the Moon. Well, taking the example of lunar station activities, we must recognize that despite ongoing divergences, there are pressing common interests. And as always, the core challenge of building such widespread consensus perhaps would be finding a balance between national interests and the broader interests of all mankind. So today I've tried to reflect on why a legal coordination mechanism at the inter-program level is crucial for being enabling life on the Moon. But as for how we can actually achieve this, I guess it would be covered by the ongoing discussion with the UN COBOS framework, and it would be the many research remains to be done. So thank you very much for your attention. As an early career researcher, I still have much to learn and explore, but I hope my perspective today has offered something useful to our conversation. And much of what I have raised remains open-minded, so I'm truly welcome for your feedbacks. Okay, that would be incredibly helpful for my ongoing research. And thank you again.
Thank you very much, Dr. Yu. Indeed, we learned a lot from your presentation. It is very detailed, and we enjoyed following the slides, which also help to follow the content of your presentation. There is a question in the chat. You can also open it to have before your eyes, but I will anyway read it so that you can address this question. The question relates to International Lunar Research Station, the very ambitious project of China. Of course, the entire world is following this project, and the question is whether there is the kind of legal framework to be developed in support of International Lunar Research Station project. For instance, a reference is made to the Artemis Accords, which are known to be promoted by the US within the framework of the Artemis program. Do you have something similar as a plan or as a draft in China?
Thank you for your question. As a researcher, and as the information I have received from many ends, I assume there is ongoing drafted or legal framework for the IRS project. However, it is not made public to the world. So I guess that would be answering the question.
Thank you. This is clear. There are some additional questions coming on the chat. I will also give you some time to read and to listen it. So the second question refers to some perhaps actual assessment of the feasibility to have a habitation on the moon or the Mars surface. Is it really feasible in the nearest future in terms of Chinese development in space technology, or it is a kind of our dream into the far future?
Thank you for the question. Well, I guess for a space lawyer, a legal researchers, I am not an expert in technical perspective. I guess I might not be giving a certain answer with that. There are proposals for both the IRS and the Artemis program, saying that by the end of, if my memory serves me right, 2030. Well, previously it says 2025. The timeline keeps delaying. So I guess there are different elements affecting the progress of how we reach to the moon, how we send people to the moon. But I guess ultimately living on another planet would be a very envisioned, ambitious purpose of deep space exploration, of outer space activity, especially for powerful space nations in the world, not just for the purpose of showing the power of the technology, and also would be a common purpose of where the human society goes, perhaps. And I guess that is the answer of the question.
And the last one also typed in on the chat. It is basically a reference to what you have been discussing during your presentation about some obligations of states to help astronauts during their space missions. Do you think there is a need to introduce a kind of an specific additional obligation for states to make sure that they can implement this obligation? For instance, to make sure that every and each state which has a space mission allocates a kind of a seat or a rescue vehicle or a rescue technology during its own missions, something specific to make sure that all states are capable of really helping astronauts, or it would be sufficient to leave on paper is a kind of a flexible obligation, and every state will decide for itself how it is going to implement it.
Thank you for the question. So I guess the question asked about two options of whether it is more possible or a more specific way of having the rules made, or a flexible way of having the rules made regarding different states' obligation of assisting personnel on the moon. Well, personally, at this moment, I guess I would tend to say that a flexible one would be in line with my own instinct. Can be seen from previous outer space treaty and others relevant treaties binding legal instruments regarding this matter, the rescue agreement. They all provide a more flexible and a more sometimes more general language of providing the obligations. When it comes to setting up, the obligations, binding obligations in treaties of outer space activities, the drafters can be very careful. So I guess a flexible a flexible approach of introducing such obligations would be more feasible if the purpose is to promote what is really effective way to help, to assist safeguarding life and health on the moon.